Good afternoon, everyone. I would just like to welcome you all to the webinar that we have today with Sarah Schütte, our third one in a series. So I can see a number of you are completing our poll. So thank you very much. This is really helpful for us to see who's in the room and who's joining us today. It's amazing. Nigeria, Durham. So lots and lots of people from a good selection of different areas. This will really help Sarah actually. So if you could just perhaps populate this with a one word, realistically is what we're after, of what's the one word that best describes your role. Interesting for you all to see who else is joining today as your colleagues and peers across the profession. Hopefully that provides you with a little bit of insight, Sarah, of who you've got in the room and the sort of questions that you might be getting towards the end of your session today.
Yes, indeed. Thank you. Welcome to all of you to this, our third in our series of 3 webinars. My name's Sarah Schütte. I run a small consultancy called Schütte Consulting Limited. I'm a trained lawyer and a specialist in project management, in particular in the construction and engineering sphere. I'm a member of APM and I also sit on the contract and procurement SIG, and it's on behalf of my SIG and my fellow SIG members that I've offered to do this webinar series. You can probably see, and some of you may know already when you attended the live events, or you've noticed from watching them on catch up, that we had an original series of this event back in 2018. Now, APM's had heaps of new members since then, and so a warm welcome to new members in the last 3.5 or so years. And for those of you who listened to or watched the original series, I hope that this new one will give you some new insights and something new interesting. The law is a really dynamic machine, and lots have changed since then, and there's also been lots of developments in project management practice, and so I hope that this is providing a refresh and something new and interesting. So as people who get involved and excited about projects and collaborating to make a difference in the world, whatever sorts of projects that we work on, we don't much like to think about the subtext to this webinar, which is what to do when things go wrong or the unexpected happens. We don't really want to think about that sort of scenario. However, as good project managers, being forewarned is forearmed. And therefore, in this final webinar today, I want to take you through completing that circle of project manager skills and knowledge about contracts, and to introduce you to 3 things which are going to enable you to have that complete skill set. The first is we're going to look at breakdown in performance. The second is we're going to look at what happens with the unforeseen, whatever that might be. The third thing is resolving disputes and issues that crop up. And then we're going to bring it all together towards the end. And those of you that last the distance will get 1 hour of CPD points. As project managers, we concentrate very hard, don't we, on our end goals, on the project, on completion and on success. But any one of these 3 things can wrong-foot us. Yeah, it can put things out of kilter or disrupt things or distract us from things that we need to do. So it's really incumbent on us as project managers to make sure that we are forewarned and therefore forearmed about the topics. Quick reminder to the series. Our mission here is to make law work for the industry. That's what we do. It's a translation piece as much as anything else. The kind of common pressures that I find on project managers are all to do with being that central piece to a project, of the need for a very broad skill set. And those of you who answered the question about, what is the key word that describes your role, most of you came up with your title of your job. I'm a project manager, I'm a commercial manager, I'm a student, I'm a teacher, all those sorts of things. But we're talking really about skills. So what is it that you do? Some of you pointed that out. Some of you said, I'm a leader. Yeah, I'm a teacher. Yeah, I work in the PMO, and you're really there trying to identify and get a handle on, and it's one of the biggest difficulties for the project management profession, is what do we actually do? So today we're going to look at some of the things that you can actually do when issues threaten to wrong foot our projects. As project managers too, we are leaders. We have people who depend on us, both for direction and for guidance, and sometimes for decision making, yeah, and for implementation and development of different sorts of things to do with the projects. Therefore, project managers really need to know about contracts. The real reasons for needing to do this are twofold. One is driven by the project itself. Yeah, what is it about this project that's going to make it successful? What is it as a project manager that you are going to do to ensure and to drive and to encourage the project and the project parties to be successful? And I've put that in speech marks because, of course, it depends how you define success in any given scenario. The second risk is for you yourself as a project manager. Okay, you have a risk to yourself if you don't do your job properly, and for those of you who are employees, to your organization as well. So as a project manager, you've got to have your eyes in all directions, both facing externally and within the project, and also facing internally to yourself, to your team, to your organization. So the driving message from this series is really get the basics from this, but be smart about it, know where your limitations are, and of course, seek legal advice on the kind of legal issues that are arising. This webinar then focusing on the following things, these common challenges during the delivery phase. You can still watch the catch-ups, and I recommend if you haven't already, please do that, because I'm going to make some cross references during this session to those other webinars. All of them are about my mission within this business to make law work, to give awareness of how contracts work, to enable you as project managers to do your jobs better. So let's look at the role of the project manager. That was actually the first question that was asked by Sarah for you, those of you who entered early. If we centre ourselves then as project managers, what are we doing for and with our projects? Now, those of you who have heard me speak before, perhaps at other events, might know I like to refer to the project manager as being the cog in a wheel. It's the wheel that helps the project to turn, the wheel that maintains momentum and encourages it, and in some instances requires it. Therefore, as a project manager, you have to be central to resolving issues. You have no choice about it. It is part and parcel of your job. Why? Because you have the day-to-day responsibility for driving that delivery. Because you are, as the manager, the natural conduit between the parties. You are, in some regards, and the law will hold you to this, a broker between the parties. You're the record keeper. Yeah, you keep record of progress, of measurement, of defects, of variations, of all sorts of things to do with how the project is going and how it's going to be recorded, and you will have that complete project record at the end of it. In addition, as a project manager, you might be empowered. Yeah, you might have a responsibility, an entitlement and an obligation to make decisions which bind the project parties. For example, you may be allowed and required to make assessments as to variation, so time allowed or additional money that can be granted. And finally, and this is the bit that relates to the second risk, you have holistically an engagement to provide professional services. And those professional services revolve around the concept of the project and what it means to get to project completion and project success. So all of those things lead us to being knowledgeable about what to do through the entirety of the project. And that's got to include some of the things we don't like to think about when we get excited about delivering a project, and that's stuff that happens when it doesn't go as planned. So as a project manager, you encourage and you maintain momentum. You are the cog in that wheel of all the different moving parts for the project, of what it means to ultimately get progress, completion and success, however it's defined. But we can get wrong-footed when things don't come up to scratch, and when things don't come up to scratch, we call it performance breakdown, and that's the first topic we're going to tackle right now. In contractual terms, a breakdown in performance is all about not meeting contractual obligations. Yeah, typically those obligations are to do with three key pillars of contract delivery: time, cost, and quality. Now, however that's going to be described, however it's going to be measured and tested within the contractual boundaries. It happens for lots and lots of practical reasons, and I've put 6 key reasons up here on the screen. Some of those relate to the project manager themselves. Lack of resource, lack of help. You're on your own. You need people to help you do your job. Perhaps you're not, don't have as much expertise as the contract and the project demands. Second is to do with other parties to the project. They haven't understood their delivery outputs. They haven't got good relationships with suppliers. Perhaps procurement's been delayed for a difficult reason, or perhaps there's not enough coordination and collaboration. And thirdly, we've got more systemic problems, to do with communication, to do with the management of people, and to do with the management of money. Project manager has got to relate to and be able to deal with all 3 of these things. So it's a real problem for projects and contracts. It's a legal problem too, unfortunately, because it might be a breach of contract. It isn't necessarily, it depends on what kind of term we're talking about, what the breach in the obligation is, and how serious that failure in performance is, whether it can be rectified or not. So please do go back to webinar 2 in that regard. There might be remedies through the law or through the contract for the other parties, such as compensation. There might even be a right to terminate, and that's really serious, of course. Secondly, there might be additional remedies, so over and above what the law would give you as a basic remedy, and those come through the contract. So project managers need to have an idea of what the contract contains by way of remedies. There might be things such as set off, so we don't have to pay you until you sort this out. There might be bonuses which are forfeited, and there might be rights to use certain pots of money in order to put things right. There might also be time dependencies in relation to performance breakdown. Obvious ones like liquidated and ascertained damages or delay damages, and defects period, which monitor defects within a set period of time. So these are definitely areas in which you need to take this wonderful combination of technical advice and legal advice to help you do your job and to lead the parties, excuse me, through a breakdown in performance, and hopefully to be able to rectify it and come out the other end and get back on track, maintain that momentum. One of the difficulties for project managers is dealing with a breakdown in performance, which is a serious one. Look at that second little arrow there. If you try to terminate but you are wrong, you may be classed as the wrongdoer and the other party could terminate you. Now that's a really difficult legal question, and it's one I have to advise on more often than I would like to, unfortunately. So we have to look at ways in which we can stop breakdown performance being able to have a termination remedy attached to it. Of course, mostly day-to-day, it's a practical problem, and it's a real headache for those of you who are project managers dealing with this sort of thing. So what can you do? Well, first of all, there's 3 key things to try. The first is to try and minimize the on-the-job problems. And the way to do that, of course, is to understand what the contract position is. So go back to webinar 1. Use the contract tools that are there, the progress meetings, the communication. Use the change control tool and the process which is there. Secondly, communicate hard. Don't just ask people to do things, but do it yourselves. Get right into the heart of what the nub of the thing is. What's the source of this problem? Communicate really hard to try to get that project back on track. We want to avoid, if we can, breakdowns in performance becoming significant distractions and disagreements such that they can't be remedied. And the third thing I would recommend to you is that you control and share. You may, and in fact, I do recommend this, seek legal advice on the issue. You might need to talk to insurers as well. There are actually quite a lot of things in this third bullet point, so do mark that as a thing to think about going forward. The main piece of advice I would give is that you're not on your own as a project manager. Yes, you're the cog in the wheel. Yes, you're keeping everybody going, but you are not the person who is meant to be a single-handed resolver of all of this stuff. Okay, you're going to need to and want to, again, for the 2 risk reasons envisaged, talk to other people, okay, so that we can support you to get to the right answer, hopefully minimize what that breakdown is, and hopefully get things back on track. But you can easily foresee why the need to control and share is there. Okay, let's move on to the unforeseen. This can be a really, really tricky one. And I don't mean things like digging up some ground and finding a septic tank. We're talking about really serious unforeseen stuff, and it can really sting. So again, useful cross-reference there if you haven't yet caught up with webinar 2. There's 2 key legal areas, and they may not necessarily be in the contract. So you need to keep your eyes out as a project manager for these unforeseen things. The starting point is, of course, what does the contract say? Well, most risks are allocated or shared in some way to one party or the other. And again, we've looked at this in previous webinars, but some risks don't. Some risks are catered for under legal principles. The first one is a concept of frustration. Frustration is all about unforeseen events that make it impossible or illegal to be able to deliver the contract, or they're events which result in such a significant change to the party's purpose for entering the contract that we call the contract a frustrated contract. I'm going to give you a few examples here, so hopefully this brings it to life a bit. A contract which becomes impossible, is one where an explosion destroys the worksite, and note that I've said a man-made explosion there. Secondly, the illegality point, an event that makes it illegal to finish the contract, a country bans imports of something and therefore you cannot supply them. So we're talking here about a distribution contract. And thirdly, the significant change point. I've given an example here of where an organisation loses its charitable status. That means it can't avail of preferential leases, but can't afford the market rate. So there is such a significant change to that party's purpose for entering into the contract that it can no longer perform it. Okay, now again, this is a really difficult legal test, so you will want to take and need to take advice on it if you think that something like this has happened and the contract may be frustrated. The second one, which you will probably be more aware of just because of the state of the world in the past couple of years, is force majeure. Force majeure has been bandied about a bit with COVID, but in essence, the legal test is all about unforeseen circumstances that prevent performance. Okay, and they have to be of the major catastrophe variety. Couple of examples here, and I've put COVID with a question mark because there are quite a few arguments going to and from about whether, in fact, COVID-19 is a force majeure event and what certain contract forms or industry associations might say about it. But it is of the major catastrophe variety. It's usually pretty obvious, but again, it can be a bit nuanced and there can be arguments on both sides. The nuanced bit might come from something like the project location, where in the local jurisdiction, the event is or isn't seen as force majeure, but your understanding from knowing a little bit of English law is that actually it would or it wouldn't be. So we just have to be careful there about non-UK based projects in that regard. Now, why am I mentioning all of this? Because I've said quite clearly it's 2 key legal areas that need a helping hand to understand. Well, because of course they affect the project manager. What can you do about it as a project manager? Well, it's really tricky in practice because the law will automatically end the contract and it will therefore allow the parties to walk away. So there's very little you can do to kind of stop it happening. It's going to happen. It will have happened in any event, whether it's a natural thing or a man-made type of a thing. But because the law treats the risk events as a neutral thing, it means that the project manager can't really do anything about it in contract terms. However, of course, the project manager is still on the job, yeah, and you must therefore be aware of these things, take advice and direction from others, such as myself, such as insurers, and then of course you've got to bring the thing to an orderly close, whether it's securing site, whether it's making sure that the project record is complete, whether it's making final payments to people, all of that sort of stuff. That's what you're going to be doing as a project manager when you come across these really difficult unforeseen things. The reality of this is that these type of events are pretty rare, but the reason that I mention them and the importance of them just to have in the back of your minds is that they have a huge impact. They have a bigger impact as could possibly be had on a project and on the network of contracts that have been put together to deliver the project. So please be aware of them. Rare, but important. Okay, let's, excuse me, move on to our third one, which I'm sure many of you will be much more familiar with, both in your generic learning and in your sort of day-to-day practice, and that is dispute resolution or resolving disputes, because dispute resolution tends to be a process rather than an active verb for a project manager. So I've pulled together here a couple of areas where you want to get clued up about, and where emergent or sticky issues that are proving quite challenging to resolve in the project space. Yeah, and because they're in the project space, it's incumbent on you as a project manager to be able to give some direction and guidance to the parties as to what they should be doing. So these two areas are as follows. The first one is the contract jurisdiction clause. So again, back to other webinars we've looked at before, we need to look at which country the dispute is actually going to be resolved in. Now, if you are in the UK dealing with UK parties and the project is based in the UK as well, 99% of chance that your country of choice for the jurisdiction clause is going to be the courts of England and Wales. However, in other parts of the UK, you might be in one of the other courts. Okay, and we don't have UK law in this regard. Each of the jurisdictions of the UK has its own court. So just be careful of that little nuance there. If it's silent, then the law will automatically imply the court because that's inherent jurisdiction within the Constitution, within the way that UK law is set up, the four jurisdictions of UK law is set up. There might be an express contract term that tells you something different. You might be, for example, in domestic arbitration, yeah, or perhaps even in international arbitration if you've got project parties from other countries involved as well. So that's one just to quickly flick through the contract and have a look and see where it's going to be if these sticky issues don't get resolved by the project parties in the project sphere. The second one then is that the contract is going to tell you which forum to use and in which order. Yeah, sometimes we call them tiers, a bit like with contract tiers, we have tiers of dispute resolution as well. And there's some examples there. You might have been involved in one or more of those in the past. You might well have looked at dispute resolution clauses and seen things of that order. You won't find all of them, of course. There'll be a selection. There might only be one or two, or there might be just a standard form clause which says this is what's going to happen. Okay, it's going to be different in each case. So again, it's just genning up on these forewarned is forearmed sorts of issues. So what can the project manager do apart from knowing the answers to these two issues? Well, there's 5 suggestions there and a little reason why. Project managers can really play their central part here. And I think in order to be able to manage that live situation on the ground, you need to have these 5 things at your fingertips. So you can kind of use them as a checklist if you like. The first one is to get knowledgeable about the options. Yeah, what is that order of steps? Yeah, and why? Yeah, so for example, in any of the 4 UK jurisdictions, you have a statutory adjudication tribunal for any contracts which will be classed as construction contracts under the Housing Grants Act piece of legislation. Okay, and that is going to trump any contract list. Okay, so whatever the contract says, if you have a contract which is going to be classed within that legislation, you'll have that statutory right available. Okay, so at that point, you've got to repivot those options. Secondly, is to understand what will be required of you directly as the project manager. Yeah, is there anything specific that I need to do at any given time? How am I supposed to do it? Who am I going to give that information to? And of course, for yourselves, you've got to think why. Okay, it might be things like project records. It might be giving access to IT. It might be enabling insurers to be assured that information is being secured and things like that. There might be quite a lot of moving parts for you as a project manager. The third thing is that you'll want to check out for your own knowledge, as well as for being that directing force in the contract, as to checking what the local laws are and the procedures for that. For example, there are in some foreign courts requirements to lodge your costs. Okay, you have to provide a bond so that you can afford to go to litigation, for example. So, you know, if that becomes the case, then as a project manager, you're going to need to know what that requires of any given project party. The fourth is back to a liaison point, this control and share point that I mentioned earlier. Communications are essential in dispute resolution. It's interesting that the more we're in dispute with someone, actually, the more we need to communicate. It's an interesting dichotomy there. But for you as a project manager, it's about a liaison point rather than putting forward a side or putting forward support one way or another for an argument. You may be asked to tell the story, okay, and you'll be there as the independent project manager for the project in question. So you might be asked to liaise with legal folks like me or with insurers about what their requirements are as well. I've already mentioned things like securing information and giving access. Again, it's a reassurance piece. You're not on your own, and don't try to go it alone. Okay, if you do, you might inadvertently go wrong, and then that comes right back round to the risk piece that I started with, which is the worry that project managers try to do all of this stuff and therefore bring risk upon themselves as individuals, as teams, and within their organizations. You are that cog in the wheel. You are there to broker, to lead, and to guide, but you're not there to be the sole voice and the only person who has the answer. And when we're talking about these sort of three things today about what to do when things go wrong or things don't go as planned, I know from project managers who are clients of ours that they feel very alone at points, and I don't want you to feel like that. So I'm re-emphasizing this point to make sure that you don't feel that you're alone and that you don't try to do it alone for the contract and legal reasons, as well as the practical reasons and the support and mental health reasons as well. So really good and really important point to make. And the fifth thing is that you will want to speak to your own association or your own accreditor. The reason I mentioned that one is that you might need their help. As part of your fees for your accreditation or your association, they may be able to provide a source of help, an advice service, perhaps a telephone advice service, perhaps even legal insurance help as well, if you need it. That sometimes comes as part of the package as well. But you don't want to do inadvertently, again, it's an inadvertent thing, any wrong that might put you in a professional difficulty as well. So from project manager's perspective, it's both looking after the project and being knowledgeable about how this dispute might have to be resolved, okay, and who might have to be involved to help you and to support you to be part of that dispute resolution. But also there is a piece for looking after and protecting yourself in the role that you do and your organisation as well. Live situations on the ground, very tricky indeed. Right, let's just have a look at this. So the good news is, that felt all a bit serious, didn't it, that last bit? The good news is that statistics are on your side, but don't be complacent, I think is the message of this slide. Knowing the options is going to be a strength for you in times of dispute. If we know our options, if we know what the path ahead is, then we have strength and we have control about how we're going to operate and how we're going to behave ourselves moving forward. Those statistics then, more than 90% of claims and project issues result in a negotiated or a commercial settlement of sorts. In other words, they are kept out of all of this difficult stuff like arbitration and court and adjudication and formal stuff. The reasons for that, lots of reasons, of course. People want to maintain and need to maintain their commercial relationships. There might be a small marketplace. Yeah, you might have specialist services to offer, or you might need to go to a specialist supplier for this kind of thing. There may be a necessity through being in a partnership or an alliance of some sort. Yeah, so you have to sort things out. And of course, there is also the much more mature option of driving a settlement for the benefit of the project. I put that in question marks because it's often an afterthought, and it's still an afterthought, and it certainly isn't at the forefront of what project managers do and want and need to do with regard to their project. But if we can have an eye on what that longer game is, if we can keep that momentum by resolving things and encouraging and guiding and directing as project managers, then we do see genuine, tangible benefits to the project coming through, such that we get further towards completion, success, and operation, etc., etc. Costs, of course, are probably the biggest reason why we have this very high number of claims resolving themselves. Legal costs, insurance costs, direct costs, having to hire experts, third-party opinions, all this kind of stuff is hugely expensive, and it's all cash up front, bottom line stuff for a business. Then there's the people aspect. Yeah, disputes of all sorts are emotionally draining. They require people to really dig around in their souls sometimes as to how they've done their jobs, how they've behaved, you know, really having to go back and look through your story and put your chronology together, all of that sort of thing. And again, if we talk about project benefits, then disputes are a distraction to what time would otherwise be spent on doing good work. So I'm really keen to help project managers to be a part of the dispute resolution piece in the active sense of resolving disputes rather than participating in a dispute resolution process. The complacency bit really comes from the very high percentage of claims which are resolved, because as a project manager you still need to understand what those options are. Yeah, the parties may have different options, and also as a project manager, and this comes back to the second risk again I mentioned to you and your organization, is that you have to be prepared to participate in it. And when things have wrong-footed us or the project hasn't gone as planned, then we have to have a weather eye on what that might mean for us as project managers and employees of a project management organization. Of course, coupled with that, you've got to then balance at the same time the project itself. You've still got to perform your duties. You've still got to contribute to the engagement piece and whatever else your contract of professional services requires. Subtext to that, and again, this is not to put the fear at people, but just to have that commercial awareness piece, that if your own performance as a project manager is questioned, if your client or the other project parties are questioning your breakdown in performance, so circling right back around to issue 1 of this webinar, then you will most definitely need to escalate that internally, and in all likelihood a professional indemnity insurance issue may arise. The important thing with professional indemnity insurance is that you don't get help and cover from your insurers if you don't tell them about it. It's a little bit chicken and egg in the sense that you need to tell them. You kind of have to alert them up front to something which might be an issue. That the law is very strict on that, and it's you can't go back on it. So if you don't tell them early enough, unfortunately, you don't get help later on. But if you tell them too early, then you can feel that it's kind of a bad thing to have done. But actually, it isn't. It's actually getting help for a potential issue. So do take advice on that. We do work in the professional indemnity sphere as well, so we can help with that as well. So gosh, things not going as planned, things going wrong in the project sphere. It's 3 really tricky areas that we've looked at for project managers today, but it's really important to complete that project skills circle. It all gets a bit serious, doesn't it, when we start talking about disputes, and that loops right back into where I started, which is the excitement of a project, the getting going, the collaboration, the making it happen. Well, we do need to bring all of that together and make sure that we have the entire project skill set at our fingertips. So I want here to bring 4 things to your collation checklist. The first thing is that naturally everybody panics when stuff goes wrong or the unexpected happens, any of those 3 types of events that I've described. However, as project managers, I want you to think about being the steadying force to all of this. You are still that cog in the wheel. You are the party that makes things happen. You get to add value here, and you maintain and still are the driving force for the project. That means that you need to have this wonderful combination of factual knowledge about the project and also contract knowledge to help you to do that job. If you get a settlement to a dispute, that's great. We maintain it in the project sphere, which is what we want to do in that 90+% of occasions. But it will need some work to it to make it stick, yeah, to make it effective. And therefore, the note there is that you need to have the contract amended, and you need a lawyer to draft that properly to make it effective for everybody involved. Third thing is to think about and have that commercial awareness for other contracts that might be impacted. Remember, a project is put together, and the way I teach it is always about structures, a network of contracts, yeah, that together comprise the project and make it happen. So giving you a couple of examples there of other contracts which could be impacted by the unexpected or by things that don't go as planned. And fourthly, it's a happy note to bring this together on, is project managers doing what they do, which is being active, yeah, helping the parties, driving things forward, and ultimately being a pillar of common sense for the project, being the party on whom people depend, on whom people seek, from whom people seek guidance and direction, and bringing all that centrality back to where I started this first webinar. Firstly. We've got a few minutes left before we go to Q&A, so I will just move to this slide with a little star on it and remind you of being that cog in the wheel. Okay, so in summary, issues arise on every project, whether a project is big or small or everything in between. No projects are immune from issues arising and unexpected things happening. What's important then for project managers is to deal with them in accordance with the law. Clearly, I've given you some pointers on that, and also the contract. And at the same time, you have to keep giving that right level of professional service. You're going to be at the center of problems because you're at the center of projects. Yeah, it is the entirety of the engagement piece. Let's look at being at the center of problems as being someone who is at the center of problem solving. Just a reminder, the law can be strict, so take advice. Okay, we are there to support and help. What's the star for? Well, the star is just a thank you. A thank you from me for joining us for this whole series of webinars. And a particular star to those of you who have attended all 3 events, especially if you've done so live. We were really interested, and we are interested, I'll be looking at the numbers later on, to see who wanted to be here live to hear this and who was needing to have or preferred the convenience of having the catch up as well. We'll continue to work hard on that at the contract and procurement's sake for sure. A couple of little pleas from me as I start to wrap this, and Sarah will take over with some questions in a minute. Do give us your feedback. As a trainer, as someone who provides workshops professionally, I really require and really encourage you to give us your feedback on how this was for you, and do get in touch with your ideas and your comments and all of those things. They really are taken into account for the preparation of our next things. My next thing on this slide is just to ask for any questions, which we'll go to in a minute. I just want to say a special thank you to Sarah Slater and to Maya Creasy, and also to my fellow contract and procurement SIG members for having supported me in running this series again. It's been an absolute pleasure. The APM has grown and developed so much since we started this series in 2018, and it's been an absolute pleasure to refresh it, shake it up a bit, and relaunch it in 2021. So that's a little thank you from me at the end of this. There are some contact us as well if you want to do that. There's a variety of modern ways, nothing quite like picking up the phone, but each to his own. Sarah's got some questions, I know, in the box, and I think we also have a couple more polls. So if you could stay, we've got 10 minutes or so for questions, and we've got some time for those polls as well. So Sarah, over to you.
Thanks, Sarah. That's another great session. It's so valuable to hear you go through all of that, and I'm sure everyone's coming away with some great insight there. So there's a couple of questions already being sent through, so I'll just get those for you, if that's okay. So the first one, and I don't know what this means, but I'm sure you do. What is /R lads? And that's in capitals, LAD, lads.
Yes. I mentioned it very briefly, but I didn't explain it. It stands for liquidated, capital L, and, small a, ascertained, capital A, damages. And what it is it's a measure of compensation. It's a pre-agreed measure, which means that you don't have to go through the faff at the time that somebody wants to claim from you. You don't have to go through the faff of trying to work out their exact damage. You have a pre-agreed sum of money that you're going to pay them for the damage that you've caused. And LADs are levied, or, well, actually in law you have a right to levy them, but you have to tell somebody about it. That's something for another webinar, I think. Common misconception in the contract administration world. LADs is a pre-agreed sum, and if you want it, you've got to tell somebody that you're going to apply it from them.
Okay, great. Thank you. That's a very comprehensive answer. Another question, it's another slightly longer one, so I'll read it through for you. Disputes usually start off as small things. Are there general rules about the need to give a supplier the opportunity to fix a problem, and when it is reasonable to fix it yourself and look to them to pay the bill as damages? Common case is when you feel the supplier doesn't give the fix sufficient urgency / priority.
Wow, there's a ton of stuff wrapped up in that question. Okay, so your first rule is your general principle that a supplier or a contractor has the right to try to fix what they have not done properly. Now, properly means whatever the contract says. In the absence of the contract telling you what properly means, then the law will give you the standard to meet as being a reasonable standard. That's a difficult one, of course, because everybody's sense of reasonableness is different. So then you have to go through expert evidence and all sorts of stuff. So the best way is to write in the contract what your expectations are as a client. Okay, well, what's been agreed, what's been negotiated as what properly is going to mean. So that's how you set the standard for what to reach. Now, as a project manager, you don't get to give a subjective view on what you feel has been achieved or not. It has to be measured. Yeah, and if you can't measure it, then you have to use your best judgment, your expertise, as a project manager, if you're not an expert in that area, which in all likelihood you're not going to be, because it's going to be a technical thing, you're going to need to go and get help from somewhere. Yeah, that might be an outsider, that might be somebody within your own organization, but somebody who is going to be more than just a feel for what you think is achieved or not, because achieving the right standard makes or breaks certain parts of the project, including payment, including completion, including things like LADs if you don't finish on time. So it's really important to get that proper assessment of what you feel has or hasn't been done properly as a task or an activity.
Okay.
Start with a contract, and if not, law will tell you the answer. That will circle you right back round, because it's such a difficult thing to try and work out, to the contract, and then you'll find an expert third party, probably supported by somebody like me in the background, to just kind of move you into that space of, here's an agreed thing. This person has come in, they've got no connection with the project at all, but they are an expert in their field. They give an opinion, and therefore everybody works with it. I'm a big fan of expert opinion, actually, and that question lends itself entirely to, has a supplier met a threshold or not? I hope that answers the first question. I'll read when it comes to me later and see if there's anything I need to add.
Yeah, I think it doesn't sound like perhaps there's an answer for one answer for all, but thank you for expanding on that. Another question has just come in, and I'll read that one for you as well. So most of us work with NEC3 contracts. They have damages and rewards. Do you believe this contract is the best suited for civil works, or would you recommend other types of contracts like JCT?
Okay, well, any of the contract forms that exist, including the NEC and the JCT, are suited there or thereabouts to doing construction and engineering works. I couldn't possibly plump for one over the other, because actually the important thing is what you do with that standard form of contract. How much do you change it? How much does it need to be changed in order to make it useful and fit for purpose? Small letters, not big ones, for the project at hand. So, you know, in certain circumstances, the NEC form of contract will be better. The JCT may be better in other circumstances, but it does depend on what you do with that vanilla contract and how then it is implemented. Because of course, you can spend heaps of money on putting the contract together, but if nobody uses it, yeah, if the parties don't use the project tools, whether it's early warnings in NEC, whether it is the extra time and variations clauses, or some of the special clauses in JCT as well, if it doesn't matter, it becomes redundant if you abandon the contract form that you've got. So, I mean, the NEC has you know, really come into the space of civil engineering. The JCT is used a lot more for building in a traditional bricks and mortar type of a sense. And I suppose there's a natural delineation, at least that's how people perceive it to be. But the key thing to understand is whatever contract you're faced with, you need to look at it and understand what it says in order to work out how it's going to help the parties to move, to keep that momentum going. And again, it doesn't matter what's in there if you don't look at it. So please do look and get help from someone who can translate it, which is what we do here day to day, who can help you with it, because they can be big or they can be small. And it's what you do with the contract ultimately that helps you to work or not to work.
Yeah.
And
okay, great.
The answers. So
great, thank you for that. So I think now, just looking at the time, I'm just going to nip over to I'm going to share my screen. There's just a couple more general questions for our audience in the room to help us with what you've heard today, and also what you might be happy and interested in hearing from Sarah and her colleagues within the SIG going in the future. From today, and I'll give you a few moments to think about this. Are there any key takeaways that you can sort of help share with Sarah from today's webinar that you'd like to put onto the Slido? So scan that QR code if you haven't already done so, or that number, and then we'll get some of those responses through. Be informed. Very sensible. Read and understand the contract.
Yeah, I love this because this is all active stuff. This is what we want project managers to think about doing, and anybody who comes on my training courses or has heard me talk in a more kind of formalized learning sense knows how much I rate active verbs. So I'm so pleased to hear these. I'm not alone. I can always seek help. Yes, I'm so pleased that message is getting through. Seek advice, be aware of your options. Don't do it when you see it on the horizon. Yeah, absolutely. Part of project controls, of course, you know, that very specialist bit of project management is all to do with the horizon piece, isn't it? Looking ahead, and being ready to act. Keep calm. Absolutely. First job is to just breathe, always. Be legal, work with the relevant people. Yeah, fantastic.
Lots of very sensible ideas coming through there, and hopefully, you know, other people's ideas will help each other to bounce off that. So thank you for that, everyone. There's still a few coming in, so I'll just go let that roll a little bit longer. The next one, which I'm just going to ask, which perhaps you can just start to think about a little bit as this one continues, is ideas for future webinars. Sarah's obviously now come to the end of her series of 3 basic contract law, but would love to hear from you with regards to what else you'd like to hear from the SIG, what would be helpful to you in particular, something you've seen elsewhere that you'd like us to expand on. So anything like that you could share with us, and that will really help Sarah and her colleagues come up with some more ideas for you. We've also got the survey that I just popped it into the chat. You can obviously add some ideas there as well. So if you've done that, thank you so much. And your feedback is very much appreciated. As Sarah said, it really helps us understand what works and what doesn't.
I'm having this to enable the project manager to add value to the tender process. Gosh, I've done so many workshops, particularly in the past 2 years. And sometimes it's so fascinating that I have delivery teams and pre-con teams in the same room for the first time. So whoever's added that as a topic, that's really insightful. Getting project managers involved early on is a real driving force for me and us here. So that's all good stuff. Closing.
We'll capture all of these responses. So although some are coming off the screen, I'll be having them all sent over to you for those ideas.
Yeah, managing clients and expectations. Yeah, definitely. Some sector specific stuff. Yeah. Best practice for preparing and defending. Yeah, that's quite a specialist one. These are really helpful. We're putting together our plan, obviously, at the moment, as many of you will be as well. And you know, this is, I was saying to Sarah before the session, it's so helpful to have this, you know, direct wants and needs stuff that we can just work with and really, you know, give events that people genuinely are asking for. You know,
absolutely.
But that's what we want to do at our SIG. So please keep them coming in.
That's great. Thank you, everyone. So I think really probably just leaves me to say a big thank you to you, Sarah, again for all your time. I know it's an hour today, but there's a lot of preparation that goes on in the background for that. So really appreciate that. And for everyone in the room, a reminder, it is in the chat, but in case you've not had an opportunity to read that, if you do want to count this today towards your CPD, then please do. There's a handout that's available to you on your dashboard, which details the way you can now record your CPD on APM. And there's also a link in the chat which takes you to the website that tells you all about that as well. So do take a look at those 2 things. And we very much look forward to receiving any feedback you can offer us via the survey. And Sarah and the rest of the contracts and procurement SIG, I know, will be sort of looking at the contributions you've done through Slido today to help formulate some plans for some different ideas and events coming in the future. So thank you. We're giving everyone 2 minutes back of your life. So there you go. Always on a plus. Hope you enjoyed it. Thanks again, everyone. It just leaves me to say goodbye and have a good afternoon.
Thanks again for everyone attending.
Thank you, Sarah. Take care.
Bye, everyone.